Hello, welcome to the ICC Annual Arbitration and ADR Conference. We are just letting a few people into the room before we make a start. Thank you. Hello, welcome to webinar 5 and day 2 of the ICC Annual Arbitration and ADR Conference. I'd like to welcome Milo Mulfer, who's also a committee member for the Arbitration and ADR in the UK. Hi Milo, welcome. Milo is going to be giving a brief introduction before introducing you to the panelists and our moderator for today. Over to you, Milo.
Right. Thank you, Natalie, and good afternoon, everyone. My name is Milo Molfa. I'm a partner in the London and Milan offices of Curtis Mallet. On behalf of ICC UK, I would like to welcome you all to the final webinar of the second day of the ICC Annual Arbitration ADR Conference. This webinar will discuss enforcement of arbitral awards. The specific topic of today's panel discussion is enforcement of arbitral awards in offshore jurisdictions, namely the British Virgin Islands, the Cayman Islands, Jersey, Guernsey, and Switzerland. For this panel, we are joined by 3 distinguished speakers based in 3 different offshore jurisdictions, each an expert in their respective fields. First, we have Christian Hay, Managing Partner and Head of Dispute Resolution at Collas Krill, and one of the leading litigators in Guernsey. Second, we have Andre Brunksweiler, a partner at La Live, based in Zurich, who specializes in domestic and international litigation, including debt recovery and insolvency issues. Last but not least, we have Katie Pearson, a partner at Harnays, who is an experienced litigator in the Cayman Islands. As you can see, a truly distinguished international panel. Today's discussion will be moderated by Richard Bamford, partner and head of arbitration at CMS in London. I'm sure many of you will have questions for our panelists arising from the discussion. Please add your questions to the discussion box on the virtual platform during the webinar, and the panelists will endeavor to address your questions. This webinar is being recorded and will be available on demand via the conference platform. With that, I will now hand over to Richard. Richard.
Many thanks, Milo. Good afternoon, everyone. So you've done the hard work. You've got your award, which is good news. Congratulations. Now the easy bit. You need to get paid and you need to recover on that award. So increasingly, we do see debtors with connections to assets in offshore jurisdictions. How do we deal with that? Historically, the assumption has always been that looking for assets and pursuing debtors in offshore jurisdictions will be a challenge. Offshore jurisdictions have a reputation for secrecy, a lack of transparency associated with low tax jurisdictions. But as we move to a world where a lack of transparency is more frowned upon, is that still the case? Was it always a myth? Or has it really been more difficult historically in the offshore jurisdictions to enforce awards? And is this changing? We're going to look at all those topics today with the panel that Milo has introduced you to. And hopefully we'll be able to give you some tips and tricks which can make enforcement in the offshore jurisdictions a little bit easier for you. So without further ado, I'm going to open the floor to the panel, and I'm going to start with Andre. Andre, from a Swiss perspective, Switzerland has a reputation of being a place where it's difficult to enforce because of the oft-cited banking secrecy laws. Is that fair? Is that a characterization which you're happy with as a Swiss lawyer?
Thanks a lot, Richard, for the intro first, and Milo, and of course to ICC for the opportunity, which is appreciated. So thanks to that. turning to your question, we're quite happy in Switzerland that we are still considered an offshore jurisdiction, of course, because that brings us work at the end. This is a good reputation because everyone wants to have, or at least wanted to have, in the past, the money parked with a Swiss bank, which then again resulted in quite some interesting work for our firms and many others, of course, in Switzerland. Now, is it difficult, and what the banking secrecy has to do with that? First, I think there are two aspects one needs to consider to your question. The first one is, of course, the very technical one. Is Switzerland an easy place to have your award enforced? As you all know, Switzerland is party to the New York Convention, as many other countries. So from that perspective, I think enforcing the award as such is not the biggest challenge. We have a very enforcement-friendly environment in Switzerland. Swiss courts, they apply the New York Convention straightforward without any local jurisdictions implementing the New York Convention. And we have, again, the Swiss courts tend to take a very, very enforcement-friendly position in that respect. It's also a uniform application, meaning that Swiss courts would also look to foreign case law related to New York Convention issues, and that's always helpful. So I would say from that perspective and more the formal side of the enforcement, it's straightforward to have your award enforced. Now, of course, what you're talking about is the banking secrecy and whether or not it's easy to get access or information about assets being placed in Switzerland. And turning to the banking secrecy, yeah, we still have that in place, and it's still working, even though it was, of course, put under pressure thanks to our colleagues and friends from the US primarily starting, and then other European jurisdictions. We all know that many have tried to hide their money in Switzerland for tax reasons and so on and so forth. That has come under pressure, but it's still in place. The regulations are still there. We have a banking secrecy. Yes, that's a fact. And it is typically difficult to get information about assets of which you're not aware. So the difficult part, I would say, is really to get information about possible assets in Switzerland, and that is typically a requirement. When do you come to Switzerland? Either you have the debtor, the award debtor in Switzerland, or you have assets, and the latter is typically the case. So you need to know that there are assets in Switzerland. And as a matter of fact, as probably most of you know as well, we don't have discovery in Switzerland, other than, of course, in many other jurisdictions. So when you apply for enforcement and of an award, typically you have to have the knowledge about the assets you want to, against which you want to enforce the award. So that's a bit probably to the first bit and my first answer to your question. Summary: easy to enforce under the New York Convention in principle, and from a formal perspective, difficult to get to know information you don't yet have about the assets. But maybe one comment to make in my experience and in our experience, it is often that award creditors, they often have more information about possible or potential assets which they couldn't even think of. But I'm sure later on we will be able to speak about that in more detail.
Thanks, Andre, and we'll definitely come back to the digging around and the seeking of information in relation to assets later on, because I think that's an important part of what we need to talk about today. But just for now, Christian, moving on to you, what's the position in the Channel Islands? Is it easy, difficult, and how does it compare to what we may be used to in the UK and from when we just heard from Andre about Switzerland?
Well, Jersey and Guernsey have also both given effect to the New York Convention and the Geneva 1927 Convention, so everything should feel very familiar to a UK practitioner. The one exception I can think of is that applications for leave to enforce foreign arbitral awards have to be on notice to the other party, not ex parte without notice, as is the case, I think, in England. But the reasons for refusing to enforce an award are all the standard ones. the well-established criteria about capacity, validity, notice, arbitrability, all of that, that they must all be met. So registration, recognition, that's all normally very straightforward. It's when you get to the actual enforcement where things can get a little more interesting. And one of my Jersey partners was recently kept busy with a case that we know at Koloskryl as Tepe. I'd be testing my Turkish pronunciation if I tried to give you the full name, but I might write it in the chat box if anyone's interested. But that case was played out in all of the Jersey higher courts, so the Royal Court of Jersey, the Jersey Court of Appeal, and then ultimately the Privy Council. And by way of brief background, Tepe, a Turkish contractor, had brought arbitration proceedings against a Turkish state-owned oil company, Botas, for unlawful termination of contracts relating to the construction of an oil pipeline. And following an ICC arbitration in Paris, Tepe was successful in obtaining awards, I think in the region of $100 million. And well, what was the connection with Jersey? Well, Tepe found out that Botas had two Jersey registered subsidiary companies. So Tepe registered the awards in Jersey in the normal way, again, very straightforward, and sought to enforce against debts owed by those two subsidiaries to Botas, their parent company. And in doing so, Tepe were invoking what we know as a procedure that we know as arrêt entre mains, which translates roughly as enforcement against assets in the hands of third parties, similar to what you might know as the garnishee order in England. That was unsuccessful, actually, because the Jersey court found that the debts in question owed by the subsidiaries were governed by Turkish law, and the Jersey court couldn't satisfy itself that if it allowed Tepe to enforce directly against those debts, that those debts would be extinguished. So it was concerned that that the subsidiaries might have to pay them twice, once to Tepe and then again to Botas if it chose to enforce them in Turkey. So then we had round two, and in that round, Tepe successfully applied to the Jersey court to arrest Botas's shares, the actual shares in those two subsidiary companies. And Botas objected to the arrests on the basis of state immunity, but the Court of Appeal dismissed the appeal, and then so did the Privy Council. And the central issue was, did the Republic of Turkey have sufficient interest or control over the shares in the subsidiaries to make them the property of the Republic and therefore protected by state immunity? And the answer was no. The doctrine didn't extend to shares in indirectly owned subsidiaries, which is obviously a relief to parties contracting with state-owned entities, though their assets aren't immune to enforcement. It would have been different, obviously, if the award debtor was the Republic of Turkey and we were seeking to enforce against its shares in Botas, then that they would have been protected by state immunity, but it wasn't. We were looking at something more indirect than that. So that was an interesting one. Those ones come up from time to time in the Channel Islands.
So I'm encouraged. I don't know about anyone else on the chat. Feel free to put some thoughts in the chat as we go. But I'm encouraged by what I'm hearing from Christian and from Andre in terms of what seems to be an enforcement arbitration friendly approach from the Channel Island courts and from the Swiss courts in the jurisdictions where historically there's been a bit of mystique around how people are doing business. So I'm coming on to Katie now from a Caribbean perspective. I mean, is that same wind blowing through the BVI and Cayman courts in terms of courts helping parties to enforce their awards and doing a little bit to really push arbitration forward?
Yes, thank you, Richard. I'd say it is. Both Cayman and BVI, like the other jurisdictions we've discussed, are parties to the New York Convention. So the procedure for recognition of your arbitral award is pretty straightforward. It's an ex parte application supported by evidence. And once you've got your order, that can be challenged on an inter partes basis. And once your award's been recognised, you can enforce it in the same way as you could a domestic judgment. So you can get a garnishee order, you can get charging orders, you can get receivers appointed by way of equitable execution. If the respondent to your arbitral award is a Cayman or BVI company and it's refused to pay, you can also apply for the appointment of liquidators over that company, relying on the unpaid award as evidence of insolvency. And again, that's a relatively straightforward, well-trodden path in both BVI and Cayman. The even more common scenario, I'd say, than having a Cayman or BVI company that's named on your award and is actually the award debtor, is where you have BVI or Cayman companies in the same group as the award debtor, and you either want to get your hands on information that they're holding or on assets that they're holding that you say should belong to the award debtor and should be available to satisfy your award. And even if the award is not actually being enforced in Cayman or BVI, you can get interim remedies here in support of your enforcement overseas. So you can get freezing injunctions, you can get receivers appointed, and you can get Norwich pharmacal orders. The courts here are slightly more cautious, I'd say, than the English court. They're not prepared to act as policemen of the world, but provided that you can show that there's likely to be information in Cayman or assets in Cayman or a Cayman company that's a respondent to your application, the courts here want to help you, particularly if you're an award creditor. So that brings me on to a case that I was involved in recently, where we acted for ArcelorMittal USA LLC in proceedings against SR Global Fund Limited in Cayman. So ArcelorMittal USA, which is known as AMUSA for short, had a 1.5 billion arbitral award against SR Steel Limited, which is a Mauritius company. And AMUSA suspected that it had been dissipating its assets to avoid paying that award by transferring those assets to two Cayman companies within its group. So it launched a global enforcement strategy. In England, it applied for permission to enforce the award and a worldwide freezing order. And at the same time, in the Cayman Islands, it applied for a Norwich pharmacal order against those two Cayman companies within the group. We at Harneys acted for AMUSA, and the Cayman court was extremely accommodating, including giving us a hearing on exactly the date that we asked for, so as to coordinate with the hearing in the English court, sealing the court file, anonymizing the list, and so on, to make sure that there was no tipping off of any parties. The whole thing ran extremely smoothly, and the judge, I have to say, seemed genuinely excited to be part of a global enforcement effort. The Norwich pharmacal order was challenged inter partes and appealed all the way up to the Cayman Court of Appeal. It's been upheld at every stage, and it's a good example of the Cayman and BVI courts being more willing to grant Norwich pharmacals in support of proceedings overseas than the English court is. So that brings me on to another important recent development in Cayman in relation to Norwich pharmacal orders. So Richard, you asked Andre earlier about banking secrecy in Switzerland. We have an act in Cayman, it's called the Confidential Information Disclosure Act, which originally came to life as Cayman's banking secrecy law. So it used to be called the Confidential Relations Preservation Law, or shortened to CRIPL, which was a very unfortunate acronym. In 2016, it was renamed from the Confidential Relations Preservation Law to the Confidential Information Disclosure Law, which I think is reflective of a broader trend away from secrecy and more towards disclosure and transparency. It used to be thought that pursuant to that act, a respondent to a Norwich Pharmacal order, if the information that it was to disclose fell within the definition of confidential information in the Act, had to apply to the Cayman court for directions before it could comply with that order, which, when you're acting for a plaintiff for the party that's seeking the information, is very unattractive, because you'd have to tell your client not only will they have to pay for their own Norwich Pharmacal application and get that order, but once they've succeeded there, the respondents then got to make a further application, which my client doesn't have control over, but my client will have to pay for, which effectively doubles the cost and adds in a load of extra delay. So for that reason, Norwich Pharmacals were not particularly popular in Cayman. But then in 2018 and 19, we had a couple of decisions where the court confirmed that, provided it's properly made on its face, there's no need for the respondent to a Norwich Pharmacal order to make this separate application under the Confidential Information Disclosure Act. So that's made the process a lot easier and really opened the door to those sorts of orders being granted in Cayman. And they've been particularly granted against registered offices. So one of the peculiarities of Cayman and BVI as jurisdictions is that you have to have a professional service provider to act as your registered office in order to incorporate a company here. And that person's responsible for making sure that the statutory registers are kept up to date and that your filings, your annual filings are put in on time and your annual fees are paid. Now, in BVI, they've had Norwich Pharmacals against registered offices for quite some years, but in Cayman, it didn't really used to happen. And I think it was because of the confidentiality issue that I just discussed. But now that that issue's gone away, they're obviously a lot easier to get. And at the same time, the amount of information that the registered offices are holding has really increased. So Cayman's come under huge international pressure, the same pressures that Andre was alluding to, I think, in relation to Switzerland, to improve its anti-money laundering regulation. And the registered offices are really bearing the burden on this, because they're supposed to be the gatekeeper to verify the beneficial ownership of any company and verify source of funds and make sure that Cayman companies are not being used for money laundering purposes. So now, whereas in the past, the documents that they held in relation to a company may have been statutory registers only, now they have to satisfy themselves that they actually understand the business. They have to hold evidence in relation to important transactions, accounts, and so on and so forth. So if you're looking at trying to get information, that's a real treasure trove if you can get your hands on it. So in summary, Richard, where there are Cayman or BVI companies involved, there's probably more information here than you might have thought, and it's probably easier now to get your hands on it than it has been in the past.
Thanks very much, Katie. So my good feeling about enforcement in offshore jurisdictions just continues, and I think one of the interesting points just emerging from what you touched on there was the notion that actually it's not just about enforcement. There are mechanisms now for obtaining information and assisting someone holding an award to really have a look at what there may be there to enforce over. And so from a Swiss perspective, Andre, are there similar types of procedures that are open to people? And in answering that question, maybe you could also just touch on the question that we've had in from the audience as well, which is whether there's any information sharing mechanisms between the UK and Switzerland in aid of arbitration proceedings in a situation where at the enforcement stage there's no discovery in Switzerland. So without wanting to, well, I say without wanting to, I have just now sprung that question on you. But if you could maybe just think about that as well at the same time, that would be really helpful. Thank you.
Yeah, thanks a lot, and indeed interesting question. I think because as we have seen, and I probably first try to address or discuss this question because that's what the audience is interested in. What we've seen, what often works well, is if we work with co-counsel in other jurisdictions, that other jurisdictions often have means and procedures in place which we unfortunately don't have or not yet have in Switzerland, in particular discovery, any procedure which result in a discovery or gathering of information which we don't have. The issue really is in Switzerland, if you want to put it very easily, is that it's very enforcement friendly, but you have to have a certain knowledge about assets in Switzerland. And if you don't have that, and you get the information of, if you attach a bank account, money's on the bank account, you will eventually know whether there are any monies on the bank account, but only at the very end, when your attachment order is final, then the bank, and only at that point in time, the bank is obliged to disclose whether or not there were any assets on the bank account. And that can be, depending on the situation, quite a long time, because if you have the award debtor being a BVI company, or the worst case, we once had a company incorporated in Marshall Islands, and then you try to serve documents from Switzerland to the Marshall Islands. After 1.5 years, it resulted with a response from a Swiss embassy, not even in Marshall Islands, because there's no Swiss embassy in Marshall Islands, some other island around or close to that, said, well, we don't know whether that company exists, we don't know nothing, and anyways, we can't serve that. And that was after 1.5 years. So we had a bank account at the end attached in Switzerland. We had a Swiss attachment order. It was all blocked, but the client didn't know, well, it couldn't proceed, and we didn't know whether there's actually any money on that bank account. And that is, of course, very unfortunate, in particular because we ended up with then eventually being able to publish that decision in Switzerland, which is the same as being served. But then the answer from the bank after 2 years was, well, thanks, there are like $10,000 on that bank account. After the client has like spent much more, of course. That was a very disappointing result, of course, not only for the client but also for us, of course. But coming back to that question, so what we've seen, what works well, we had is if in aid of the Swiss attachment or before, naturally before you have some procedures in place or even pending abroad. For instance, we had an interesting case where we worked together with a Liechtenstein co-counsel, where they have started criminal proceedings in Liechtenstein against the award debtor for some criminal offences which related to avoidance of paying your debts and kind of and even for fraud and forgery of documents. And of course, through these criminal proceedings, they were able to get access to documents which you would typically not get, and were then quite helpful for us, because with these documents, there are various contracts establishing and being useful evidence to demonstrate to the Swiss courts that Liechtenstein foundations have been abused, I would say, exactly to hide the money. And these Liechtenstein foundations, we also found information about Swiss bank accounts and Swiss companies whose shares are owned by the Liechtenstein Foundation, and that opened up a lot of possibilities here in Switzerland as well. So that's a bit probably to answer the question. Of course, the difficult part will be if you start proceedings abroad. Of course, this will warn the award debtor there's something going on, and if he's careful, and they typically are very careful, they of course then try to move around their assets and find other interesting jurisdictions to hide their assets. So of course you have to be careful that you coordinate these actions well, and that's often a challenge. Maybe coming back a bit to Switzerland, what is interesting still, probably the basics are really that you start, when it comes to interim measures, you really start your enforcement action in Switzerland with typically attachment proceedings. So typical situation is that you have some knowledge about assets, typically a bank account or a Swiss company or real estate, and then you give it a try. And the good thing is you can really give it a try without any risk, because request for attachment of assets, you have technically speaking, your award not first enforced or declared enforceable in Switzerland, but you do that in the context of these attachment proceedings, and as only a preliminary question, which can also be quite interesting, because if you miss out of one of the formalities of, I don't know, not being able to file a legalized copy of the award or the arbitration agreement, then you do not have a risk of a res judicata, that you have a final decision on the enforcement, which is a risk you typically do not want to take. And now the interesting thing, or the good thing, is that these applications are dealt with on an ex parte basis. And if you fail, whatever reason, the Swiss courts say, look, I'm not convinced that the information you provide me on the asset, that's not sufficient, the negative decision will not be notified and not served on the award debtor. So you can go back, do again your homework, and then give it another try, to put it bluntly. And of course, then the technicalities, I don't think we need to speak about that in too much detail, but it's quite a technical procedure. Of course, once you have your ex parte decision attaching ideally some assets in Switzerland, then of course there's an entire procedure and following to have that checked and verified on an inter partes basis. That's of course then the follow-up, and it's often a bit forgotten, to be honest, because these attachment proceedings can be very long, can be very technical, can be very costly, and once you actually obtaining the attachment is only the starting point. That's often forgotten then, until you have really access to the assets, and you that can be quite still a long process and a costly process.
Thanks, Andre. So I think we've all learnt that there are a number of mechanisms open to us to try and ferret around and see what assets there are. And I think in all the jurisdictions, I think we can be encouraged by what we've heard. What I'd like to do now is move on to a different but related topic, which is trusts. Now, a lot of business is in offshore jurisdictions is carried out via trust, as we know, and certainly we hear that on a regular basis. Christian, from a Channel Islands perspective, is there anything that we would need to know about enforcement of awards as regards trusts? How does it work? Is the position different? Should we look out for anything in particular when looking at trust assets in the Channel Islands?
Yes, well, it's going to be difficult if the assets you're interested in, you think the debtor has an interest in, are actually held in a trust. If we're talking about a properly administered discretionary trust, and we nearly always are, where legal ownership in the asset vests in the trustees, and the most that we can say is that the debtor is a discretionary object of the trust, and with no fixed or ascertainable interest, then it will be difficult, I'm afraid. But sometimes the court will see through the trust in appropriate circumstances. for example, if the court finds that a defendant, the debtor, actually has a right to call for the assets of the trust, or he has de facto control over those assets such that the trustees aren't actually exercising any discretion, then the court could permit the use of the trust's assets to meet the liabilities of the defendant, the debtor. That's what happened in 2015 in the English Court of Appeal case of Pugachev, otherwise known as Putin's banker. So in that case, there were so many powers reserved to the settlor, to Pugachev, that the court held that the trust was an illusion, that the trust was illusory, so that the assets really belonged to Pugachev. So I think that the court appointed a receiver to over the assets to apply them to meet Pugachev's liabilities. So and those kind of decisions are not binding in the Channel Islands, but they're going to be highly persuasive. And the courts in the Channel Islands are increasingly nowadays going to be very mindful of the need to protect the reputation of their bailiwick. So they'll be at pains to assist an award creditor. There's one of the decisions, a judgment, some dicta that's often used in similar cases is that of Richard Southwell, one of the Guernsey Court of Appeal judges, and in a case that he heard involving the president of Equatorial Guinea, he said, frequently litigation relating to assets in Guernsey is current in another jurisdiction, especially England. The Guernsey courts must ensure that Guernsey doesn't become a safe haven for those who may wish to evade financial liabilities. So that, as I say, that's often cited when we're trying to persuade the court to look through a trust or a corporate structure.
Thanks, Christian. So in summary, a work in progress, but again, going back to the theme that we identified earlier on, that the Channel Islands looking to assist holders of arbitral awards, and I suppose in our words, we might call that as a more pro-arbitration stance, even existing as regards trusts, although it's always more difficult because of the legal structures. Katie, what about the Channel Islands? Would the Cayman Court permit enforcement against a trust set up by a judgment debtor? Is your position similar to Christian's, or is it a little bit different?
It's very similar to the position in the Channel Islands as Christian just outlined. So we do have a precedent in Cayman for enforcement against a trust. That was a case called TMSF and Demerel. It was a Cayman case that went all the way up to the Privy Council, and the Privy Council's decision was issued in 2011. And what happened in that case was that Mr. Demerel was a judgment debtor. He had a judgment against him in Turkey, and he'd set up 2 Cayman Islands discretionary trusts. And the Privy Council held that the judgment creditor should be allowed to appoint receivers over his powers of revocation of those trusts. So that the judgment creditor was able to get their hands on the money in that trust in that way. Similar to what Christian said, the Cayman courts are very keen to assist judgment creditors or award creditors, and they're also very wary of Cayman companies being used to commit fraud or to conceal assets. So if there is a suggestion that that's what's taken place, the courts will do all that they can to assist.
Thanks, Casey. So similar type of views in what I might call the common law jurisdictions. From your perspective, Andre, as a civil lawyer, all this talk of trusts may be completely alien to you. I mean, is it something which is remotely relevant to enforcing in Switzerland? Do we see trust concepts at all in the process of enforcement in Switzerland, or is it something which you just don't see?
Well, as you probably know, we don't have, so Switzerland does not have its own trust laws, but of course we recognize, and this is always a bit in flux of discussion, and there are projects in place to have our own trust law, but it's probably not that likely that this will happen any soon. However, Switzerland recognizes foreign trusts on the basis of the Hague Trust Convention, of course, and then whether or not you can enforce your award against assets of the trust or in trust structures really depends then logically on the law which is applicable to the trust. So what is probably to mention a bit a similar situation is what I mentioned before. We had this huge enforcement case in Switzerland, Liechtenstein, and Germany about a major award, and in Liechtenstein there was this family foundation which were able to crack on the basis of a legal opinion we had from our Liechtenstein Cone Council after they have had access through these criminal proceedings I mentioned before to all the trust relevant the family foundation relevant documents, including, and of course that was exceptional, an affidavit of a former employee of the award debtor stating that the award debtor is just hiding its money through the Liechtenstein Foundation, which was of course very helpful. In addition, we had like all the mandate agreements the founder, the award debtor, had in place with the local structure and the local administrator and the foundation council in Liechtenstein, which gave broad powers to the founder to request disbursements out of these family foundations to him personally. Of course, this was an exceptional situation. You probably don't find a second time, but it is then based on all these information, we were able to convince the Swiss judge to really grant the attachment of all the assets the foundation had in Switzerland. So that's a bit how Swiss courts probably deal with that these trust structures. Yeah.
Thanks, Andre. So I think just we've got a little bit of time left, and there's one more topic that I'd like to cover with you all, and it's something which Katie touched on earlier on. More often than not, in dealing with enforcement of awards in your jurisdictions, one may come across a situation where the award holder is company A, but actually you have a real feeling, or indeed you know, that the pot of gold is somewhere else within a complex corporate structure, and that gives rise to this whole question of piercing the corporate veil and the extent to which it's possible to do that in your jurisdiction, or to look behind where the award holder is. Katie, you just touched on that earlier on, but is that something which, consistent with the case that you referred to, which the Cayman and BVI courts are interested in doing, or is it still, as we know in the UK, traditionally quite problematic to pierce the corporate veil in a true sense and look behind the actual debtor?
Well, the doctrine of piercing the corporate veil exists in both Cayman and BVI. The principle's the same as it is in England, and without wishing to teach anybody in this session to suck eggs, the Supreme Court in England set out the principle in the Petrodel and Prest case, and it held in that case that where a person's under an existing legal obligation or liability, which he deliberately frustrates by interposing a company under his control, the court may then pierce the corporate veil for the purpose of depriving the company or the controller of the advantage obtained by the company's separate legal personality. So in those very specific circumstances, it would be possible to pierce the corporate veil, but as the Supreme Court said in that case, those situations are going to be very rare. Outside of that kind of situation, I'd look at other ways of getting at the pot of gold. So I'd look at applying for a declaration that the pot of gold held by party B is really held on trust for party A, being your award debtor, and therefore should be available to satisfy your reward. Or I might look at putting, if the party that's holding the pot of gold is if the award debtor is a Cayman company, I'd look at putting it into liquidation and then letting the liquidator claw back the pot of gold from party B. Or similar to what Christian said his colleagues did in the Tepe case, I'd look at getting a garnishee order against the party that's holding the money, or a freezing injunction under the Chabra jurisdiction, where you can get a freezing injunction against a non-cause of action defendant. Or the ArcelorMittal litigation that I mentioned before was an example where we got disclosure from group companies that had been mixed up in wrongdoing by the award debtor. So overall, I think it's going to be difficult to persuade the court to simply disregard the corporate form. But if you think creatively, you can normally find a way to get relief. And as I've already said, if you're an award debtor or a judgment debtor and Cayman companies have been used to commit fraud or conceal assets, the courts are going to be very, very keen to help you.
So what I take away from that, Katie, is the word creativity. And I'm sure everyone listening has over the last 45 minutes got some ideas as to how to be creative. So Andre, what about creativity in Switzerland? Piercing the corporate veil, easier, more difficult? If we can't do it, what about creativity in Switzerland?
Always, as you know, Swiss people are very creative. We've invented chocolate, cheese, and all the good things you all love. So that's definitely available. Now, to turn to your question, the doctrine is of course well known as well. Two conditions to mention: you have to establish, if you want to pierce the veil, kind of an economic element, meaning that the company and the true owner behind forms like an economic unity, whatever that means, and however that you can establish. That's the second question. And you have to have an element of bad faith. So of course that one tries to hide behind that corporate structure. These are the two very general conditions. And now of course it's a case by case situation one needs to look into. We have applied that doctrine many times successfully, even through two layers of company. So we went again to become the example with the Liechtenstein Foundation held shares in Swiss companies, and the Swiss companies then held real estates in Switzerland. And we were able to attach the real estates in Switzerland, which were commercial real estates with rents coming in every month. And if you attach the real estate in Switzerland, you also attach the fruits of the real estate. I mean, in this case, of course, the rents, which put a lot of pressure on the real estate companies, because that was pretty much the only source of income they had. They feared an issue with their banks who financed the acquisition of the real estate, because they became aware of this. So this was a very powerful tool also to bring the parties on the negotiation table. So you have to be creative, but it's difficult to apply the doctrine, but we've done it several times successfully, and it's possible. The issue and the difficulty is often from a procedural side that you need to have your case with documentary evidence only in these Swiss enforcement proceedings at the attachment stage, and that can be a challenge. But maybe I stop here in the interest of time, Richard, because Christian might want to give his views as well.
I'm sure he does, and indeed, thanks, Andre. Christian, I'm going to give the last word on this topic to you. Piercing the corporate veil, is that something that the position is any different in the Channel Islands?
No, I mean it's available here. And Katie's already helpfully outlined the principles that the court will apply. And it's going to be difficult, isn't it? Because as I understand it, the it relies on the structure being put in place after the event, deliberately to frustrate creditors, which it happens, but it's something that you need to have really good evidence on. I mean, the thing that happens more often as a matter of practice in the Channel Islands is lifting the corporate veil to aid enforcement. So sometimes it's on an interim basis, sometimes it's on a final basis, so that assets owned by third-party companies, which are beneficially owned, let's say, by the debtor, can be preserved. There was a case in Jersey some years ago, which some of you might have heard of, Garnet Investments, against BNP Paribas and the Republic of Indonesia. And in that case, the Jersey court lifted the veil and determined that Mr. Putra, the son of the former president of Indonesia, effectively sat behind Garnet Investments to the extent that the assets of Garnet should be frozen, so that to ensure that any judgments against Mr. Putra weren't rendered nugatory. So that often happens, lifting the veil to preserve the position, piercing the veil, bit more difficult and less common for sure. Again, like as Katie said, if fraud is alleged, if fraud is proven, then the courts in the Channel Islands are going to bend over backwards to find a way to assist an award creditor.
So I quite like that distinction between piercing and lifting, and I think what we're hearing from everyone is that this idea of, okay, you're not going to explode it completely, but actually the courts are being more sympathetic to people who are trying to look behind these things, and as you say, just lifting it slightly to get in there. That seems to be the way things are going, which I think, as far as our audience is concerned, as people who are hopefully representing people with awards, they're going to be encouraged by that, I think. I'm mindful of time a little bit, and we've got a question from the audience that I'd like to touch on now with you all. And that question is, and it maybe has how long is a piece of string, but give it a go anyway. What would be the typical duration of enforcement proceedings in your respective jurisdictions? So we could draw lots for who goes first, but I'm going to go first with Katie.
Thanks, Richard. I think with how long is a piece of string, you hit the nail on the head there. I mean, and also it depends, what sort of application we're talking about. If we're talking about the straightforward applying for recognition of your arbitral award in Cayman, that's a pretty straightforward application, at least the initial stage. It's an ex parte application, which generally should be heard pretty quickly. It's a question of how soon we can put the papers together, and then really how soon the court can make a judge available. But on those sort of applications where there's no need to factor in the other side's availability, you generally would be heard pretty quickly, within a week or two after filing the application. Then where things get interesting is if it's challenged by the other side, because then inevitably you have one party, the award creditor, who wants everything dealt with as quickly as possible, and then you have the award debtor trying to slow things down and wanting time to put in evidence, and their counsel's not available, and so on and so forth. Even in those circumstances, the court doesn't generally put up with too much messing around. So I would expect your first instance inter partes hearing to come on probably within a month or two of the initial order being made and served on the award debtor. But then there's a right of appeal to the Court of Appeal, and from there on to the Privy Council. So if, as in some of these cases, there's a huge amount of money at stake, billions of dollars, and parties wanting to slow things down, these sorts of litigations can drag on for a number of years if they're making use of all of their appeal rights.
Thanks, Katie. Just one follow-up from me on that. Is it the case that there's an automatic right of appeal, because that will obviously add time, or is there a threshold for appealing in the Caribbean?
So that it depends what sort of order you're talking about. If it's a final order, then there's an automatic right of appeal from the Grand Court to the Court of Appeal, and from then on to the Privy Council. If it's an interlocutory order, then you have to apply for permission to appeal, and that's harder to get. And then you can also have a fight over whether it is an interim order or a final order, which can also take some time to sort out. So it's not always as straightforward as we would like.
But presumably an order for enforcement would be regarded as final, I guess.
Yes, yeah, an order for enforcement would be final. We had there's an issue with, for example, like Norwich Pharmacal orders. Are they supposed to be interlocutory or are they supposed to be final? They are supposed to be final, but there are various there's some fights that can be had over these things.
As they say, that's probably a conversation for another day. So
yeah.
Thank you. Andre, what about Switzerland? Can you give us a minute and a half on this question? I know it's very specific. I'm trying to keep it calm.
That's good. Of course, I can give a very concrete example. We started on this big enforcement case. So the attachment decision on the attachment, which gives you a preliminary idea whether first your award is good enough, and second whether you will find assets or successful may be successful in finding assets, and will be available on ex parte basis, so within a couple of days. We filed an application, had 3 days later a decision from the judge granting the attachment request we filed. And that was in 2019 summer, but right now we're still fighting and at the second appeal level about whether or not this attachment should be upheld or not. So this is now 2 years later, and the client, of course, only still has the attachment, but first we don't know whether there's anything on the bank account, and second, we're far away from actually getting paid. Well, not we, but the client.
Typical? And it's a concrete example, but is that typical?
It's typical that if you have the award debtor based outside of Switzerland, yes, because all these notifications through the channels, they have to go take some time, and that's often what really prolongs also the enforcement of the proceedings.
Okay, thanks. We're just about out of time. I'm going to come to Christian just to pick up on this last question now. But while we're doing that, if anyone has any last questions, please do ask them on the chat, and we'll endeavour to squeeze them in at the end. Christian, question for you then. Same question. Time for enforcement.
So the registration, the recognition bit's very, very straightforward. I mean, it's a matter of weeks. Actual enforcement, it depends on so many things. Do we need to get creative? Do we need to start applying for interim relief to ascertain and preserve the assets? I mean, that Tepe one that I mentioned, the Turkish, I think that was 2 years from start to finish. I could be wrong, but it's about that. I mean, but that went all the way up to the Privy Council. There were 2 appeals in there. The one interesting thing about Guernsey law, a quirk, is that we don't have bankruptcy. We have something called en désastre. And the effect of being en désastre doesn't get you off the hook. You're always liable for that debt. So a creditor can come back in 10 years' time, and if the debtor has found some asset somewhere, then you can enforce against them. Being en désastre doesn't absolve you. Once you've exhausted the assets that your debtor has, that's not the end of the story. If suddenly he finds a pot of gold in 10 years' time, you can come back for it.
Excellent. Well, I like a bit of Norman law to conclude things. Just one quick question for you, Christian, just to follow up on some of the other things we've discussed. Privacy in the Jersey and Guernsey courts. I've certainly become aware of situations where some of the cases are dealt with in camera in Guernsey and Jersey. Is that the case with the enforcement questions as well?
Well, no. I mean, I can see why you might think that, because lots of Channel Islands judgments have quite confusing citations in the matter of the A trust or A, B, C, and D against F. But as with most other jurisdictions, the starting point is going to be that proceedings happen in open court, and justice doesn't just have to be done; it has to be seen to be done. It is common for administrative trust matters to be dealt with in camera with privacy, some kind of privacy orders attaching to them. That again is not the starting point, but it's the kind of unwritten rule that administrative trust matters, perhaps not wholly contentious matters, will be dealt with behind closed doors, especially where the interests of children are going to be discussed. Then you'll almost certainly have a degree of privacy. But it's changed actually in the last few years. I mean, going back 10 years, you and I were involved in a case in Guernsey, a shareholder dispute, where all we had to say to the court was, it's going to affect the market price, the value of this company if it gets out to the market that these shareholders, these directors are fighting each other. And that was enough for the judge to, the fact that it might, people might lose their jobs was enough for him to grant a full privacy order. Well, it doesn't work like that now. There's much more pressure for matters to be dealt with in open court, and unless there's one of the very few exceptions apply, then it will be in open court.
Okay, thanks, Christian. So just squeezed in under the wire, one last very interesting question, actually, and it's a shame that we have got relatively limited time. So I'm going to ask you all for 1 minute on this question, if we can, if people just indulge us for overrunning slightly. And the question is as follows. That's pretty concerning, these delays and hurdles to get the award enforced in your respective countries. Are you saying the winning party to the arbitration should go to other jurisdictions to enforce his or her award more easily? If so, which ones? So in other words, put another way, is it particularly difficult in your jurisdictions, or are there going to be hurdles everywhere you go, and these are just the ones you identified in your jurisdictions? This will be the last question, and it's probably the hardest one we've had to answer all day. So I went first with you last time, Katie, so I'm not going to do it again to you this time. Andre, any thoughts on that last question?
Thanks. Accept the challenge. I don't think often you don't really have a choice. I mean, if you know where do you want to go, that's where we started. I mean, either you go there where your debtor is based, or you go there where there likely any assets, and then you can't really choose. Okay, I go, I don't know where, and just enforce it. Well, if you end up with no assets in that jurisdiction, it's difficult. So I think the question, of course, is very much justified, because as we have heard, I think all these jurisdictions have their issues and challenges. But what we have also heard is that there are ways to work around that. And again, I think if you know of a Swiss bank account, you should come and you have to go to Switzerland to try and give your luck. And the good thing is what of course, it's concerning if you're can last 2 years and the attachment, the assets are still attached. But what I've seen, often you have some dynamic and some momentum. If you're able and successfully apply for an attachment, you have the award debtor who might be very much interested in actually coming back to you and say, okay, now you hit me where it really hurts me. I have, as we have seen, these commercial properties attached. I have issues now with my banks and so on and so forth. My reputation with my other business partners is at risk and so on. I can't make payment because my bank account is blocked. And then he's or she's often forced to come back to you and say, okay, come on, let's settle and let's discuss now a settlement on the enforcement. So I think my conclusion would be, come to Switzerland. We're happy to help and work and find a way to work around these issues.
Great ending. Well done. Thank you, Andre. Christian, see if you can outdo that ending.
Well, what I would say is, remember, we're dealing with an abnormal situation here. We're talking about where your award isn't actually against the person or entity who has the who has the assets. So I suppose I'm going to ask you to have a think about if you could have been more careful, more thoughtful about who your judgment or award was going to be against. Is it possible at an earlier stage in the proceedings to think about who has the assets and make your judgment or your award more enforceable than it is otherwise? So give that a lot of thought. Give thought to the wording of the order, the wording of the award, and that could help things considerably.
Thank you, Christian. And Katie, absolutely the last word to you.
Well, that's a good point, Christian. I like that point about thinking about enforcement at an earlier stage and making sure that the order that you get is tailored to the parties and the jurisdictions where you're going to try and enforce. I know we've all been talking about the hurdles to enforcement that we've faced in our own jurisdictions. I have to say, having practiced cross-border for my whole career, I haven't come across a jurisdiction where there aren't hurdles and difficulties and opportunities for people to drag things out if they're so inclined. But if anybody else does have a jurisdiction where that's not possible, I'd be interested to hear about it. But I think, as the others have said, you've got to go for where the money is, where the assets are, where the companies in question are, and you've got to be alive to what the other side's going to do, what delays are possible, and try and, as I said before, think creatively and come up with a way that's going to minimize that delay.
Many thanks, Katie, for that. So look, thank you everyone for your time, and particularly thanks to my panel. And that was really, really interesting. And I think the word that shines through, just before I hand it back to Milo, is creativity. Katie mentioned it just at the end there, but I think that's the watchword for all our jurisdictions. This was a truly international panel as well, which I thought made it particularly interesting. I just jotted down some of the exotic locations where cases have been referred to in this. I've got Turkey, Mauritius, Equatorial Guinea, Indonesia, Russia, Liechtenstein, and last but not least, the Marshall Islands. So thank you all for our journey around the world on enforcement. It's been a pleasure to work with you all, and back to Milo. Thanks very much.
Thank you very much, Richard. Obviously, I echo your thanking our wonderful panelists. If I may just have one, my key takeaway from today's discussion, it's that while the virtually worldwide application of the New York Convention ensures that there will not be additional legal challenges when seeking to enforce a foreign arbitral award in offshore jurisdictions, of course, we've seen issues relating to the application of banking secrecy law, disclosure of information of assets, lifting or piercing the corporate veil of a trust of a corporation located in an offshore jurisdiction are likely to make it more difficult as a practical matter to find and therefore attach assets. But that is not a function of arbitration. And I think that this is a very important point. I mean, parties seeking to enforce a foreign or indeed a domestic judgment in an offshore jurisdiction, I believe, are likely to face the same difficulties. And what I just wanted to leave the audience with that thought without giving the impression that these difficulties are peculiar to arbitration. They're not. This concludes our discussion on enforcement of arbitral awards of today and the second day of the ICC Annual Arbitration ADR Conference. Thank you very much to everyone who has attended this panel and day 2 of the conference. The conference will resume tomorrow at 11 a.m. London time. The first webinar of the day will address updates from the ICC network and will focus on Singapore. We look forward to seeing you all then. Good evening to everyone, and thank you all. And back to Natalie.
Thanks, Milo. Thanks very much for taking part. And yes, we'll see you tomorrow at 11 for our penultimate session. And then we have ICC Brazil as well in the afternoon. Thanks, Richard. Thanks to all our speakers and Milo for helping out too. And we'll be making this available on demand very, very shortly. So do catch up if you want to watch it again. Thanks so much. Bye.